All right. Well, thank you for everyone for joining us on this really complicated morning, right? With these flood storms and everything. I hope everyone is safe and sound and nothing got flooded where you are. If you're home, stay home. Don't try using the subway right now. Take it from me. So today we're talking about protecting your ownership in jointly held real estates, prenups, LLCs, joint ownership agreements, and trusts. So the focus of this is basically when you buy real estate or you hold real estate and you want one more person owning it, how should you set it up? You know, what are the best ways, ideal ways to set up? And there's a lot of ways to do it, as you're going to find out. So let's dive in. So second. So yeah, just the first page here. This is mine and my colleagues Talida's profiles. We have our contact information here, emails as well. So if you guys have any questions after this webinar, just feel free to get in touch with us. We'll be happy to help. And it doesn't necessarily have to be a question about this webinar. It can be any question about trust and estates in general. And
hi, Chris. Chris, good
yes.
morning. Hi, I'm here. Sorry, I had an issue with my computer, but I was able to access through my phone.
Okay.
Good morning, everyone. Thank you so much for being here with us today. And I'm sorry.
No problem, Talida. This is, we just, so just started. I'm not sure if you can see anything, but I'll go ahead and do the presentation. If you have any comment, just feel free to come in, okay?
Of course. I'm not able to see your screen, but I'll use our material so I can follow you through.
All right.
Okay.
So,
all right.
First quote, I always start my webinars with this quote. Everyone has an estate plan, either one created by themselves or one created by the state. If you die without an estate plan, it goes to intestacy rules. Don't let the state dictate who gets what. Get a trust and estates attorney to make things more straightforward and go to the people you want. It's just a real quick slide I put here of an importance of an estate plan for everyone. Ensures individuals that the planning objectives, the right people inherit the assets. It's planning for both life and death, appointing healthcare proxy, durable power of attorney in the event of incapacity. Ensure the right people are picked for the positions. That's so important. Executor, trustees, guardians, right? You don't want unfamiliar people making those decisions, not only after your death, but during your life in your most vulnerable position. Conditions can encompass both succession and asset protection. We do asset protection as well as part of the succession planning. Limits discord between families at death and potentially decrease or eliminate any potential estate or income taxation on built-in appreciation. So that's always good to keep in mind. So let's go over holding title, just real basic, 4 areas here that we're going to cover. So one, we're going to go over holding title with one or more individuals, right? So that's basically, John Doe and Jane Doe on the title. Then we're going to go into holding title in entities. Number 3, we're going to cover holding title in trust. And then 4, we're just going to shortly touch on a combination of the above, for instance, a hybrid entity, a hybrid structure like an entity together with a trust. So let's begin. So number 1, holding title with one or more individuals. So if you've been in my webinars before in the past, you've probably already realized that I've gone over this, but it's always good to just get a really quick refresher just on these terms, not just for yourselves, but also professionally, just so you can understand that the more you hear these and the more you get used to them, to the expressions, right? So holding title with one or more individual, again, this is like John Doe and Jane Doe, right? So we have 3 basic types. We have tenants in common. So that is pretty much when you hold title with an individual, that is the default, right? A default, at least with someone that you're not married to, or the individuals aren't married, they're not between spouses. So if John Doe and Jane Doe, unrelated parties, or even related, but son and dad, a child, parent, grandparent, grandchild, no matter what, if it doesn't have any other language other than just their 2 names on it, it's called tenants in common. All right, tenants in common is basically very straightforward. It just means each person has a equal interest in the property, and it can be unequal in interest if it's written out specifically. It's like 60-40%. And if that person passes away or dies, then the interest held by the deceased goes to their estate. So typically you'd have to have some sort of probate administration proceeding in order to transfer the real estate. Another thing that we'll touch on a little bit more is it can get a little bit complicated when you're trying to figure out whether to rent, to sell, because you have to have everyone on the same page. So if everyone's not on the same page, it can be very, very complicated, as we'll later find out. Second is joint ownership of rights of survivorship. So this is essentially sort of the same thing as tenants in common, but at least in New York, joint ownership of rights of survivorship, joint owners is basically you own 100% of it. So if you have like 3 people, for instance, and it says with rights of survivorship, then upon the death of you've got A, B, and C owning it. Upon the death of A, B, and C are now the sole owners. If B dies, then C is the sole owner without any need for probate or anything like that. That comes with its own complications. Simple way of estate planning, but does have its own complications, as we'll go over. 3 is the tenancy by the entirety. This is really just for spouses, right? So tenancy by the entirety is basically presumed when husband and wife purchase property together during the marriage, right, with both their names listed. It's presumed to be a tenancy by the entirety, and that is one way in which, although it provides creditor protection, you can't undo a tenancy by the entirety unless you either divorce or you have the consent of both spouses. So that's another issue there too. So I just went over this, so I'm just going to skip this. This is what I just discussed, and it's just for your information. We're going to send out a copy of this presentation afterwards, but let's keep going. So holding titles individuals. So with every part of this, I'm just going to go over some very quick pros and cons here. Holding titles. So what is the pros of holding titles individuals? Well, the obvious first one is it's straightforward. It's no cost. It's the default method, right? So if you just have the husband and wife on the deed, then that's it. There's no cost. You'd have to create an entity. You'd have to create a trust. You don't have to retitle anything. It's ideal if only 2 individuals, just a spouse without any other heirs, right? So if you got 2 spouses and they have no kids, they really have no other family members, there's no specific friends they want to leave it to, and they're just going to, on the death of the last surviving spouse, they're going to leave everything to charity, for instance, then this might just be the ideal way to do it. Have it in both their names by tenancy by the entirety or joint ownership with rights of survivorship. That could be one way of doing it for sure. And maintain tax exemptions, right? So this is one of the most common ways that you hold real estate, especially when it's a primary residence. So at least here in New York, and typically in most other states too, if for your primary residence, you have various tax exemptions. So you have star exemption here in New York, which lowers your school bill. And you also have IRC 121, if it's the prime residence of one individual owner, which basically means you get it, you get exempted from the first up to $500,000 of capital gains upon the sale of your residence, your primary residence. So, and if you put it in other structures, it can get a little more complicated. It might cancel out that benefit. And then lastly, ability, you can actually enter into simple partnership agreements. You don't actually have, for partnerships, you don't actually have to have a register with the state, although it's highly recommended. And as a lawyer, I'd actually be committing malpractice if I didn't advise someone to at least do something along the lines of an LP or an LLP. But this way, if it's at least for a for-profit venture and the clients really don't want to go through this expense or hassle of registering a limited partnership or an LLP or what have you not, then the rules for partnerships that basically kick in. There's laws on the books called the Revised Partnership Act, essentially, for the state of New York, and those have default rules for partners. Now, what are the cons? Well, if someone dies and it's not owned jointly, then you've got probate administration, especially if there's a tenant in common that is deceased. And this is very, very common. We see this a lot with older deeds, right? Before a lot of planning tools were known, people would just put them in their own individual names as tenants in common, then they die, and then their heir dies, and then it creates, I'll tell you, an absolute nightmare. In terms of titling the property. You have to open up numerous probate administrations or probate proceedings. Joint tenancy, as I mentioned before, can be problematic if the last surviving owner does not properly plan or all of them die together. Like we said in our earlier example, you have A, B, and C that own it jointly. So they all think, okay, great, well, we're covered here. We don't need a trust. We don't need anything. We just, if one of us dies, the other gets it. Well, what happens if you're on a car and God forbid you're in a car accident, you'll die? Then who does it go to then? And we've seen that issue before in the past too. Tenants in
Chris,
common.
I think one thing that I'd always love to tell my clients in terms of like joint tenancy of right of survivorship is that we think that it's a little bit of an incomplete, estate planning, because only the people also that it's mentioned in the title, in the certificate, for example, in the deed, it's going to inherit. So it's kind of, it doesn't go first there. So it's always good to consider that too. I mean, that's something that we always like to mention that to the clients.
Yeah,
that's all.
Absolutely.
Mm-hmm.
Absolutely, yeah, and it just creates all sorts of issues because some of them don't realize that their children or grandchildren, their lineal descendants, won't get a part of it, right? That it's like, so it can really screw up estate planning. And not only that, there's also potential tax liabilities. If you put people, gift tax liabilities, if you put someone on and they don't pay you for it, then you technically have to file a gift tax return and potentially pay gift tax on that if you're above your exemption.
And especially if you're a foreigner as well. So
exactly.
And
if you're a foreigner, just forget it. You don't want to be putting a foreign non-resident has almost no exemption, so there would be a huge gift tax issue there. But another one as well is that tenants in common requires sign off of all tenants. If there's an issue with no consensus, then we require costly partition action. So if one of the tenants in common wants to rent it, the other wants to sell, right? And they can't figure it out and they're throwing each other's property out of the windows, right? Which is not uncommon. This happens. Then essentially the only way really out is for what we call a partition action in Supreme Court, which is the trial courts of New York. And those are long, they're costly. The court will essentially be evaluating each person's positions, the fair market value, and then ultimately determining what should be done with the property. And if it's sold, then what price it should be sold. And that's a position no one wants to be in, right? Because not only because of the legal bills or the complications, but also just because at the end of the day, you don't want a judge, a random judge, essentially making that decision for you. I put here again, it's like if the real estate is held as for-profit venture, then individuals will be treated as partners in the default state partnership laws. And that is not necessarily a good thing because, I'll do, if I could see all of you, I'd say hands up who knows the default state partnership laws. Who knows it? Who knows what happens if someone dies, becomes incapacitated? No one knows the default state partnership laws. People just know the default state partnership laws when something bad happens and you need to start suing someone. So don't rely on those. And then lastly, no limitation of liability in regard to property. Owners are individually liable, right? So any tort that happens, any slip and fall on the property, you're going to be held liable as the individual, and they would potentially be able to come after not only the assets, the actual property, but also all the assets in your own individual name unrelated to the property. So 2, let's go into holding title in entities, right? So this, for me, I see anyway, is a really, really great alternative to hold title when you have multiple owners, right? In most situations, at least when it's not family members, this LLCs, corporations, limited partnerships, those actually tend to be the best way to do it. Basically, multiple owners can hold an interest in the entity as opposed to a direct interest in the deed of the property with the entity owning the property. So if you have, a company ABC LLC, right, in New York LLC, that's the one that's going to be on the title. And then underneath that, you have the governing documents, right? So for an LLC, for instance, which is typically the most popular type of entity, you'd have what's called an operating agreement, right? And then in that operating agreement, it's very, very flexible, very, very flexible. And that's why we love LLCs. It kind of combines the best of both worlds, like a corporation and a partnership. And it can be really flexible. You could do a manager-managed entity where You just have a manager calling all the shots, and the members essentially just have the economic rights. You can list and who can be the manager, who can be a successor manager, who has the rights to vote on the managers, whether property can be sold or not without member consent or just by the manager. So there's a lot of different ways you can do that. And that is just such a much better way of doing it, because then you're able to see everyone's rights very, very clearly in this one document or several documents. And it would, if it essentially avoids issues like you would have in tenants in common, where you have a partition action, right? That can be long and drawn out. So it's something that we highly recommend. And I just listed here some of the most common entities, which is like corporations, limited liability companies, limited partnerships. So, corporations, you have bylaws, and you can also have shareholder agreements between each shareholder. Limited liability companies, like I said, is the most popular one. It's a relatively recent creation from the late 70s, early 80s, I think. So, and then you have limited partnerships as well, and that you could do with a partnership agreement. And of course, one of the, let me, if I can just get into the, if I can just get in. So what are the pros and cons here? Well, so pros, like I mentioned, most practical strategy for non-related owners and for-profit motives, right? So if you got a property and you're looking to flip or rent it with individuals for profit, this is the best way to do it, right? Either an LLC, limited partnership, what have you not. Typically LLC. I love LLCs because it really gives the maximum protection to limit liability compared to the other structures. Number two, privacy. Right, only the name of the entity appears on the deed, and the governing documents, they're not filed with the state, they're not made public. An operating agreement or bylaws are private documents, and so no one has access to that, not at least without a court order. And so the only thing that you would be able to see on the deed is just the name of the company. What I had mentioned previously, division of management versus members, shareholders, partners, right? That's all very clearly delineated. Operating agreements, as I mentioned, the best way to confirm each person's rights and interests in the entity. Then you have, like I mentioned before, limitation of liability of members, shareholders, limited partners for actions of the manager, director, and general partner. And even the manager, director, and general partner can be insulated if the right formalities are followed of the entity. And one person or several persons can be appointed to vote to manage the entity, to determine when to sell, rent, etc. This kind of avoids gridlock between tenants in common and expensive partition actions, right? So now it's not to say gridlock can never happen with entities. It absolutely can, but with something that's really a well-drafted operating agreement or bylaws or shareholder agreements, those can be pretty rare, much rarer than holding individually. Now, what are the cons? Of course, there's always cons. There's always like a balancing act here. Cons, it's first of all, there's a cost to form and maintain an entity, right? I mean, to form a New York LLC costs hundreds of dollars in terms of filing fees and publication fees. There's, and then, you have to put the documents together. You have to open up a bank account, the name of the LLC. You have to basically, second point, follow all the formalities of the entity. It must be respected. Otherwise, you risk losing the limitation of liability, something called a doctrine called piercing the corporate veil. So if someone sues the LLC and then says, well, it's just, it's they really keeping it all in their own individual accounts. They're not respecting the formalities of the LLC, and therefore we should treat them as if they individually own it rather than through the LLC. The court will probably grant it, and then they can go after all the members' personal assets. Also, entities are ineligible for star exemption. So if this is going to be a primary residence or intended to be used as a primary residence anytime now or in the future, an entity is probably not a good idea because you're going to lose that star exemption. And, especially if you're older, if you're a veteran, if you're a firefighter, they all get additional exemptions and you will lose all of that. So not recommended. And also ineligible for Section 121 exclusion. So that rule that I mentioned about on the sale of a primary residence, where you could get, for a married couple, you can get an exemption up to $500,000 of the first $500,000 of net capital gains in the sale of the residence. That won't apply if the entity has more than, if it's either a corporation or if it's an LLC, which is considered as a disregarded entity for or a pass-through entity for tax purposes if it has more than one member. One member, an LLC, still qualifies if that one member used it as a primary residence, but more than two members, even if they're like husband and wife and they use it as their primary residence, no longer qualifies. So, so you got to really step carefully there.
And Chris, one thing that I wanted to add it here is that it's very, very easy to form this type of companies and fast. So it's not going to delay a closing or your deal, you know what I mean? We can form a company like that in a day. So that's something that we had a couple of weeks ago, someone that was doing a closing, and the client wanted to do LLC, and you know, they were a little bit confused and oh, it's going to take a lot of time to form the company, and no, that's not going to happen. We can do that in a day. So that's something that you should always to consider.
I mean, yeah, it's basically kind of drop what you're doing and all hands on deck, right? And we do that. We try to do that very rarely because then we kind of have to ignore the clients. But yeah, basically, I was able to do an LLC, a New York LLC, within, I think it was 3 hours. I had all the documents, even EIN numbers and all that. And so, yeah, we're able to do it right in the last minute if need be. But it's something that should be considered first before titling into it, because if it's the wrong, it can't be undone. It's just you're going to have to undo it. You're going to have to transfer the real estate from the LLC to the individuals. So it's always best to discuss with legal counsel first. So let's go to number 3 now, which is holding title in trust. And if you've had our webinars before, if you know us, you know that we love trusts, trust and estates attorneys. It's half of our name there. We love the document. It's great for succession planning. It's great for potentially for asset protection in the right circumstances. And it can also decrease or eliminate estate taxes. And not only that, but it's a very flexible document. So very, very basics of a trust. You know, there's 3 parties to a trust. There's a settlor, there's a trustee, and there's beneficiaries, right? So you can't really have a trust without having all 3 now. Having said that, a very, very common planning tool just for succession planning purposes, not necessarily asset protection or for tax purposes, we do a revocable living trust. The client is typically the settlor, the initial trustee, and the initial beneficiary, with remainder beneficiaries in the event of their death, and a successor trustee in the event of their death or incapacity. That is perfectly acceptable and allowed in at least here in the United States. Property must be retitled to living trust during lifetime to avoid probate, right? And also for it to be governed under the terms of the trust. If you have a trust, and that's very important distinction too to make with real property. With a lot of personal property, you can just do a very simple declaration that we typically put at the end of the trust. It doesn't work with real estate. You can't just put in the trust, I hereby transfer real estate. It has to be titled like as if it was a sale. So there has to be a deed, it has to be notarized, it has to be sent for recording with New York City Register. And that's not only here in New York, that's anywhere else as well. You know, this trust planning is ideal. Like I said, it helps with settlers' incapacity. Successor trustee can step in upon current trustee settler's disability. You don't need to go to court for it. There's not going to be fighting to determine who knows best. The settler's already put in there who's going to take control. And depending on the terms of the trust, the only person that needs to sign off on a sale or rental of real estate is the trustee. So let's just keep going here. Whoops, sorry, I went a bit too fast. So pros and cons of holding title in trust. So pros. So I just came up with these really off the top of my head, but you know, ideal planning tool for related parties to handle questions relating to death and disability. Yeah, it's just a great tool, especially if you're married or you have family members, you have kids from a previous marriage, you're in a second marriage, you want to ensure that everyone gets a fair piece of your estate. It's the best way to do it. And like I said, trusts are very flexible. There's really not many terms that you cannot put into a trust. There's very, very few exceptions, what we call go against public policy. Like you can't say that someone, you know, you can only get a distribution. A beneficiary can only get a distribution if they, you know, divorce a certain person. Like the courts aren't going to enforce that. And it maintains also a certain level of privacy, right? Because if you title property in the trust, then only the name of the trust appear, although the trustee's name does appear. You typically have to say such and such person as trustee, because the trust doesn't exist without a trustee. So, but if you want to have like a third party, like you're professional, like an accountant or something, or a lawyer, at least act as trustee and then title in their name, you can absolutely do that and maintain the privacy. Management maintained with the trustee, while beneficiaries maintain economic rights, subject to the terms of the trust. In the correct situations, the right situations, you've got protection from creditors and liability protection, depending on the type of trusted party. For instance, we do a lot of irrevocable trust, like Medicaid asset protection trust. So I've done some Nevada self-settled trust, spendthrift trust for beneficiaries. So the first two I mentioned, the Medicaid asset protection trust, Nevada self-settled trust, outside of the scope of this. Basically, those are irrevocable trusts. They allow, both of those allow the settler, who's the creator and funds the trust, to put things in an irrevocable trust and then be a beneficiary to a certain extent, right? Now, those are a little bit of a higher level. It's not really worth it unless you have some serious creditor issues or you have thinking you're going to need to go on Medicaid. But suffice to say, the typical rule is if a settler creates an irrevocable trust and transfers property there, a creditor, whether present or in the future, can still grab those assets. But if you put it in the right state and under the right circumstances, that can be avoided. And also, when properly structured, a trust maintains star exemption and also the IRC 121 exemption that I've mentioned. So, but again, there's some rules that allow it, some don't. You could have situations where a trust is eligible for the star exemption and not eligible for the IRC 121 exemption, right? Star exemption is a little more straightforward with trust and IRC 121. Trust can also have several settlers, right, with the power to add property, revoke, and have property returned, or have an irrevocable trust, right? So settler has no power to revoke or amend once property interest is transferred. So if you have several settlers, right, and they come up to an idea, it's like, okay, well, we want to leave this for certain family members, right? And they're both owners individually. They can both put it into the trust, right? They can both be considered the settlers. And if they wanted to, they could back out if they decided, with a revocable trust at least, the settler can say, I don't want to keep the property in there anymore. So settler A takes their part out, puts it, retitles it in their name. The settler B can still keep it in the trust. You can even do an irrevocable trust, right? So A and B put it in and they can't actually revoke it, at least not without the consent of all the beneficiaries, or potentially what we tend to do is a protector. So you can have some sort of third party that can sort of mediate. And then if one decides that they don't want to be in it anymore, then that third party could potentially revoke the trust and transfer it back to the settler. In the right conditions, though, that's very important to keep in mind. So what are the cons of trusts, though? I mean, obviously there's cons, there's balancing out everything. Well, first, property must be formally retitled to the trust. So you do have to go through the process. It's not terribly complicated, really. It's not very expensive. If it's a revocable trust, then and the beneficiary are essentially the settlers, then there's really no real property transfer tax issue. And if it's a gift, there's also no real property transfer tax issues. It's not an ideal vehicle for business relationships. There are business trusts, but those are fairly rarely used. The more common way of doing it is either through an entity, if you have a business relationship, for profit relationship. A revocable trust is also the most common type of trust and can be revoked by a settler. So if you have beneficiaries in there, right, then their rights can easily be canceled if the settler has the power to revoke the trust. And obviously, and last of all, this is with irrevocable trusts. Obtaining a mortgage or refinancing can be more difficult or expensive. It's higher interest rates because banks tend to see irrevocable trusts as a higher risk proposition. All right, so the last part of this is combination of hybrid holding, and then I'm going to talk very quickly about prenups because that's very, very important to mention in married couples. So combination hybrid holding, this is sort of relatively straightforward. We don't have to go into this too much, but basically this would be a combination, and we do this all the time with clients. So for instance, an LLC with a membership interest owned by a trust, right? So you can have An LLC, and you have partners or members A, B, and C. C wants to make sure that the membership interest is passed down to certain individuals in his family, or that there's a certain trustee that will take over that. And so he could put his membership interest into a trust, right? So you could have a property that's owned by an LLC that's then governed by an operating agreement, right? And then the operating agreement states what the membership interest is for each party, like 50-50 between A and B can then put that 50% into a trust that in itself dictates how the membership interest will be utilized, right? Of course, that's subject to the operating agreement, the governing agreement of the LLC. But done correctly, it could be a really great way not only of planning for the future, but also for protecting the interests of the members and for closely held family business interests, those kind of things. All right, so the last point that I want to talk here is special considerations for joint ownerships by spouses. So we've now gone all over this. So what are those? Well, let's talk about divorce, right? That happens, unfortunately, happens a lot more often, I think, than we would like, but that's the reality that we live with, right? Divorce. So a simple ownership or trust agreement between spouses, either in a trust or in an entity, will not protect a spouse in case of divorce. When I mean protect a spouse, I mean from another spouse's claim, right? In terms of it being divisible for equitable reasons as marital property. Upon a marriage, any property interest that a spouse brings to the marriage is their own separate property, right? So if you're the owner of, let's say, for instance, the spouses before their marriage decide, okay, we're going to buy this property in an LLC and we're each going to own it 50-50, right? And so thinking that, well, whatever we bring is just going to be, so they could be spouse A can own 50%, spouse B can own the other 50%. What happens though is that upon marriage, even though it comes in as their own separate property, during the marriage, such property could gradually evolve into what we call marital asset, right, over time. And that could be subject to equitable division in the event of divorce. And so it can get very, very confusing to determine what is actually considered a marital asset and then how it should be divided. And at the end of the day, the person that's going to come up with that decision is a judge that you don't know and is unfamiliar with the business. The only way to keep separate property from becoming marital property, so for instance, you have a membership interest in an LLC and you don't want it to be turning into marital property subject to division in the future, is with a valid prenup or postnup agreement, right? Courts will not allow prenup or postnup formalities and requirements to be circumvented, right? So you can't just say, oh, well, I have an operating agreement here with my spouse. And this makes it very clear that we just own 50%. Hey, we even put in the operating agreement that none of this will ever be considered marital assets. That's not how it works. Prenups and postnups have their own very specific formalities, very separate from like an operating agreement or bylaws. And so that's not really going to circumvent the process, right? So I know some people sometimes think to have that because operating agreements, dividing membership interest in operating agreement tends to be more palatable than discussing with a bride, like a potential bride, a prenup. But yeah, that's going to end badly, really. So don't try it that way. And then last of all, I just put this in here. This is actually from the last presentation, but there's also a spousal right of election. If you pass away and you own 100% of the membership interest in LLC that just so happens to be worth a lot of money, your spouse could potentially, and you decide you want to leave it to, a son that your son or daughter or a third person that you think would be able to handle the business better. Well, that spouse can step in and say, I invoke my right of spousal election, and they could take up to a third of that. So it always helps to plan ahead and to talk to a trust and estates attorney if you're thinking of disinheriting a spouse, at least from a significant part of your estate. So with that said, I think we've come to the end. So obligatory disclaimer. Information provided for this presentation is not intended to constitute legal advice. We're not your lawyer, at least not yet. General information purposes only, blah, 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 must not the most up-to-date legal, or maybe not the most up-to-date legal or other information. We got to do this. Sorry, we just want to create a whole bunch of attorney-client, unwittingly create a bunch of attorney-client relationships. And questions. So I'm actually going to look in because I see we have a couple here in Q&A and chat. Let me start off. So first question I see here, Brian. Is it necessary to have a joint venture agreement in addition to the operating agreement for an LLC? Brian, it's a good question. So it really depends on the circumstances, right? It depends on the parties. So what we tend to have is there's no right or wrong question for this. Like an operating agreement, for instance, you can have 2 members or 3 members, and those can be individuals, those can be entities, right? So for instance, if let's say, for instance, Johnson & Johnson and Merck wanted to go into a joint venture, then they could actually create an LLC, and then 50% would be Merck, and then 50% would be Johnson & Johnson, right? And it's essentially the same principles here, right? And then they could have a separate agreement outlining those rights as well between them. So it's very flexible. So you can do it any way you like. Mark, you can form an LLC in one day, but how do you satisfy the state publication rule? Good question, Mark. So the state publication rule is actually, it doesn't have to be done in order. When the LLC is created, then it's already valid. And then after the LLC is created, from the date that it's created, you then have 120 days to complete the publication rule. So for instance, I had a client last week, we created an LLC for him. So that LLC is already valid. He closed, he purchased the apartment in the name of an LLC. And now we have 120 days to satisfy the publication rule. And actually the publication rule, obviously as a lawyer, we keep on top of this. We make sure that that all our clients do it properly. But having said that, the publication rule, if you don't do it, and it happens a lot of people kind of, especially laypersons, they don't understand the publication rule. So then you end up having an LLC that goes on for years and years and years and never actually published, did the publication. What happens there is that basically the LLC exists as an entity, right? It doesn't cease to exist. Or anything of the sort. There's no deemed dissolution or anything like that. The only problem is, for instance, the LLC gets sued, then it won't be able to file an answer until it can show that it met all the requirements, right? And then in that kind of circumstance, then you can file the publication and show proof of it. And then another question, Shu-Chu, can a trust own several LLCs? Absolutely, a trust can own several LLCs. Yeah, a trust can own 1, 2, can own participation in 10 LLCs. Really depends on the client, really depends on the circumstances, right? But that's actually not an unusual thing. We create a lot of trusts that own, that participate in more than one entity. So let's just see here. I got a couple in chats. Okay, I got one from Brian in chat. Is it possible to form the LLC out of state, even though you do business in New York City? Yes, Brian, it is possible. We actually do that a lot when you want the maximum amount of creditor protection, for instance, and you just want creditors to only have a charging order. It's out of the scope here, but basically we tend to do those, for instance, in Delaware, because Delaware law will control. Delaware is the most creditor unfriendly jurisdiction there probably is out there. And but the thing is, if you're doing business, a Delaware LLC is perfectly capable of doing business in New York, but it has to register as a foreign LLC for it to have effect in New York, and that includes the publication requirements and all that. So you can't just trust me, we thought about this back when we started doing this. We thought, oh, well, just go to Delaware or Florida. It's much cheaper, and you'd have a publication requirement there. No, wrong. If you do business in New York, you can use your Florida LLC, you can use a Delaware LLC, whatever, but you'd have to file as a registration as a foreign LLC, and that requires a publication. So for that foreign LLC. So yeah. From Jason, if you purchase an apartment in New York City, can you register in a different state LLC, not a New York State LLC? Yeah, I think I just touched on that. Yeah, it's a similar question to Brian's. So Jason, absolutely, yeah, you can have you can have like a Wyoming LLC, you can have a Wisconsin LLC. Yeah, you can have a Delaware LLC, and that can purchase real estate here in New York. There's absolutely no rule preventing it. They can engage in whatever kind of business on a similar level as a New York LLC. However, they do, depending on the activities, they would have to register as a foreign LLC with the New York State Department of State. Hopefully that answered all the questions. And let me just double check here. I think that's all the questions we have. I'll just give it a few more seconds, see if anyone else has it, but otherwise, I think we're good. More, going once, going twice. All right. Well, I think that should wrap up our webinar presentation today. Thank you so much for everyone for coming. Just let you know, again, feel free to reach out to us with any questions or comments, and not just about entities, but also trusts and estates as well. Our contact information is on the presentation. Everyone will be getting a copy of this presentation, as well as an email, as well as a link to the recording of this webinar. All right. Thank you so much, everyone. Thank you, Oliver.
Thank you, everyone.